Thank you.
Justice Sotomayor?
We no longer have expenditure limits, so there isn't any judgment as a courtesy of this court. So there no longer is a judgment about how much is appropriate on expenditure limits. What is at issue is a very discrete issue of how much is appropriate to avoid the appearance of corruption with respect to contributions. Now, you said something to Justice Kavanaugh that I want to underscore. Your brief and petitioner's brief spent a lot of time explaining why Colorado 2 should be overruled because of the changes in the 2014 law. You disavowed that. You think the law was unconstitutional without those changes, correct?
I think, yes. I think it was the doctrinal changes in this court's jurisprudence would be alone sufficient. I think this is just an easy case because you could say those intervening changes in doctrine plus the amendments.
Before the change that permits national convention support came in the wake of eliminating public funding of conventions. So it's a way to make that up. With respect to the party headquarters, once they're built, are not tied to any particular candidate, so there's not a problem. With respect to ballot counting, the election has already happened. That was the whole Cruz case premise, which is how can there be a quid pro quo corruption after an election? I dissented there. Nevertheless, that's the court's holding, so why would it rely on that change here? With respect to the issue of donation for party headquarters, that was part of the FEC regulations long before the 2014 elections. So I think you were wise to give up those changes as a ground for saying this law is unconstitutional. What you have to rely on is saying that McCutcheon and Citizens United and Cruz changed the legal landscape, correct?
So to be very clear, I'm relying on both. I think certainly the doctrinal changes alone would be sufficient, but I just want to, and the reason I think the 2014 amendments are important is I think taking a blinkered look at the import of being able to have unlimited party coordinated expenditures on not only election recounts, but litigation over the election is a pretty big deal. The election hasn't been called at that point. That's actually the heat of the moment in the election when one might think.
But you can't change the voting. Now, can I go back to that point? Whether it was McCutcheon, Cruz, or Cruz, both cases relied in large measure on the lack of coordinated contribution limits. And you are trying to take that central part of our precedent out of the equation now.
So just to push back, I don't think both of those precedents treated the party coordinated expenditure limits as the only thing preventing a different result in those cases. Quite the contrary. What the court said in particular in McCutcheon, it mentioned the party coordinated expenditure limits almost as an aside. What was far more important in that case, and again, the reason why we're in a multiple prophylaxis on prophylaxis universe here, is the court was also talking about the increased efficacy of earmarking regulations went on for quite some time with respect to how that was something not even considered in McConnell, let alone in Buckley, as well as the enhanced disclosure requirements and the fact that with a click of the mouse, you can now see exactly whether there is some grounds to be suspicious of quid pro quos going on because of otherwise irrational donor behavior. So no, I don't think the party coordinated expenditures were treated as the be-all and end-all keeping those schemes from otherwise being unconstitutional, nor
and those earmarking rules, if you look at the Crew amicus, you will note that they weren't completely effective in stopping the earmarking that occurred in that case.
Respectfully, I think that is just an effort to relitigate what McCutcheon looked at and what McCutcheon said, which is that the breadth of earmarking refuted the observation in Colorado too, that earmarks are just— In
McCutcheon, we were looking at expenditures. We were not looking at contributions. And that's what the Crew amicus brief example was talking about.
McCutcheon was a case about the aggregate contribution limits. And again, the court said that earmarking restrictions had grown more efficacious over time because the FEC significantly broadened them, and you have to run the risk of very significant penalties if you use earmarking to circumvent contribution limits.